Actually, for the stray dogs matter, sorry.
1501 for the admin.
We discharge the CAG, the committee has been disbanded, dissolved.
Yes. Lord, this is a matter, my lord has issued notice, my lord, it's a bail matter, my lord, the matter is now showing for 16th of January, my lord. I'm only requesting not to be deleted.
No, that not to be deleted.
I'm so glad.
Civil 802. This is a civil appeal matter filed under Section 38 of the Advocates Act. There is a stay in this application, Your Lordship. I'm for the complainant. I filed a vacate stay application. It has lastly listed on 3/12, and thereafter it has been deleted. No tentative date has been shown. I kindly give you a date on this civil appeal, Your Lordship.
Thanks for the.
Much appreciated.
Your Lordship, it's a civil matter showing up on 27th January. I'm only requesting not to be deleted, Your Lord.
Not to be.
Lordships, may I beg to mention an item? We have to file hard copies of the policies, Your Lordship. We have to file hard copies of the affidavit. It's a disposed of.
In which matter?
Sorry,
In which matter?
disposed of matter, Your Lordship,
You have to file hard copies.
of the affidavit.
File it.
Your Lordship, we can't file it through the e-file portal.
क्या प्रॉब्लम है इनकी फाइल करा दीजिए भाई डिस्पोज ऑफ मैटर में एफिडेविट अब आफ्टर द मैटर इज डिस्पोज ऑफ यू वांट फाइल एफिडेविट
Lordships had directed that we should file an affidavit stating that we will vacate the premises.
अच्छा ऑलराइट अंडरटेकिंग ऑलराइट एक्सेप्ट करा दीजिए इनकी अंडरटेकिंग
Your Lordship, in the stray dogs matter, I appear for Fendicos. Our implement application was accepted in August. Our IAs are on record. If Your Lord could just allow us to file the DD, please.
फाइल दी
The DD. The implement
Let
application.
me not file it. We granted you so much of time till November.
Your Lordship, we
Sorry,
depend on crowdfunding.
Sorry, no. Yes.
With my Lord's permission, I mention item 60 that is listed today. My Lords, I have instructions to withdraw the petition.
Item 60.
Yes, ma'am.
Who appears for the other side?
My Lords, nobody appears.
Nobody appears.
No, nobody.
It's a fresh matter.
No, my Lords, it's a 2017 SLP.
2017 SLP.
Yes, ma'am.
What is it about?
My Lords, the question that has been raised is whether the plane can be rejected under Order 7 Rule 11 of the CPC on the basis of the averments submitted by the defendant and they don't form a part of the plane. So that was the question of law. However, the dispute has been settled between the parties.
Very well. लिखिए भाई आप एक नाम लिखिए so and so upon instruction states are you the AOR?
No, my Lords, Mohit Paul is the AOR. I am from his office.
You give your name to the court master.
I'm going to say it.
Okay, your lordship,
On behalf of Mr. Paul. Sorry.
Upon instruction states that this petition will be dismissed as withdrawn as the parties have already settled their score outside the court. Petition is accordingly dismissed as withdrawn.
your lord.
Much obliged, Your Lordship.
In which case it is pending. You were granted time to file. You were granted time to file rejoinder. Then when the matter comes up, then you very well tomorrow you bring your rejoinder affidavit.
Your Lordship's kind permission, this matter is coming up tomorrow, Your Lordship. This matter was, by this Honorable Court has directed me to file counter on 8th year. So I want to file my counter.
You could not file it in time.
I could not be filing time. It is coming
Very
up
well.
tomorrow.
You were granted time to file.
Yes, Your Lord.
All right. ले लीजिए इनका counter.
Your Honor, this is the stray dogs matter which is coming tomorrow. I filed a intervention application. It's already filed with the registry. I'm just requesting for that to be listed tomorrow because Your Honor will be seized with the matter tomorrow.
If it is in order, it will be listed. If it is not in order, it will not be
It's
listed.
in order, Your Honor.
No. We are not permitting. You can't keep coming every day.
Your
It
Honor,
is not an unending this thing.
Your Honor,
We have granted enough time. There is enough publicity, everyone knows. Whoever wanted to come in time and has made the deposit, we will hear. Next case.
As per the office report, the similar matter has been dismissed.
Dismissed. Thank you so much.
Wait, please, Your Lordship. Your Lordship, this is,
Item one dismissed, huh? Yes.
Your Lordship, it is a case involving non-compliance of this Lordship's order dated 4th.
Issue notice returnable on date दे दीजिए इसमें 17 February. Personal appearance at present is exempted.
Great.
Next. Yes.
Contempt of Lordship's order. The respondents are not completing.
There is no complaint. Very bad. लिखिए issue notice. इसमें जल्दी की डेट लगाइए 3rd February. Personal appearance at present not necessary.
For the caveator. The allopathy doctors, that cannot be equated with the other streams of the medicine. There are two different streams. The category is different, departments are different, service conditions are different. Now, as a matter of fact, in one of the matters.
We understand,
Yeah.
question.
Yeah.
That's all right. There's a reference, we have read
Yes,
the reference
reference.
order. But so far as ACP is concerned, that is applicable to every employee under the state service.
Yes, so far there, others are concerned, all of others are covered by another SAP, different one. For that it's a 4 years, 11 years, 17 years, 18 years. And these people are governed by that.
Okay.
Only for this particular department.
9727.
Yes, by virtue of the fresh this one, it has been done with the concurrence of the finance department.
Very well. File your counter federal.
We will. Only question. All right. They have not granted us the ACP so far. So on interim, I am only here. Otherwise, we will file the counter. There is no problem.
Reference over, we can deny it. Reference pending on the main issue.
I agree.
Obviously,
I agree.
before that
Now,
is decided, you can't be given the benefits.
the point-
Otherwise, there will be an issue of recovery.
Let me just.
Why face that situation?
Let me only
Wait
make.
for some time. You are not without salary. You are getting
have-
salary. It is only a question of
What has
little
happened?
more that you can get.
What has happened is, my lord, that
Yes.
after serving for about 30 years and odd, these respondents have now retired without a single promotion in their entire career.
All right.
So this ACP, enhanced ACP was given to medical officers on the basis of the central government pattern, saying that they hardly get a single promotion in service. Central government gives it not only to allopathic doctors, to all. Now, if they have adopted the central government scheme, which is giving to all,
So and so has put in appearance on behalf of respondent number.
all private respondents.
All the private respondents. As such, no notice need be sent. Let counter affidavit be filed within 4 weeks. Petitioner will have 2 weeks thereafter to file the rejoinder affidavit. In the meantime, what stay do you want?
Stay of contempt.
Here, contempt proceedings pending before the
May I
High Court shall
suggest
remain
one thing,
stay.
Lord? Till the reference is pending, your lordship would consider it.
Yeah.
On interim, your lordship may hear us after reply, my lord, because these people, they have got nothing.
You
Zero
don't
promotion.
dismiss your contempt, you will record your statement. You don't proceed with your contempt, you will record your statement.
That is the same thing, my lord, whether your lordship orders or I say, it's the same thing. Only your lordship may list it sometime for at least
Mr.
consideration.
Bhatia, you understand everything, let it be. The order will write.
Of-
Delay of it, which orders don't कर दीजिए. Wait के लिए. Next.
All right, my lord, my colleague is saying he is filed wakalat only for respondent one, let the others be.
अच्छा, all right. So and so appears for respondent one only, as such notice need not be sent to respondent one. Other unrepresented respondents may be duly served.
The gross and grave misconduct of a judicial officer has been condoned by the High Court by merely saying that because in 145 section he has been acquitted.
Notice returnable within 4 weeks. In the meantime,
The stay also.
further operation, effect on operation of the judgment shall remain safe. Mr. Madhyal,
Please have page 10.
Mr. Shailesh Madhyal, you should have been dismissed this. We fail to understand how the High Court has.
No, may I just show one para?
You manage your influence,
They were-
got all the witnesses stand to stand.
There was an
Doesn't make
MLA on the
difference.
train, my lord, this appears to be a
Disgusting
dispute between the-
conduct of a judicial
So and
officer.
so has put in appearance. You are on caveat or at one?
on caveat.
On caveat.
For respondent number one.
So,
May I just, please.
1 minute.
Yes.
You file your reply. We will not hear you. No.
Respondent number one.
This is a shocking case, huh? One number one. Number two, who is number two?
Was the state.
State. State, that's all right. Notice where you sent to the state, respondent two only.
Because there is a delay of around 80 days.
80 days delay condone, effect on operation stayed, and counsel for the respondent one may file counter affidavit within 4 weeks. Petitioner will have 2 weeks thereafter to file rejoinder affidavit.
Much of.
This after expiry of the aforesaid
That
period.
even the medical examination says he was not intoxicated.
Mr.
Any, I'll file my reply.
Was there a
The
concurrent
news item could
records?
not have been printed without any cleanliness.
No,
really.
question is, my lords, what actually happened over there? In
Yes,
fact, my lords, one of the dissenting
He urinated in the
was
compartment
that there was
where
a
the lady.
delay, there was a dispute between the MLA and this.
That doesn't mean that you will do what
No,
you
no,
have
so
done.
there is not a
Moving
single,
train. Leave it on.
there is not a single piece of evidence that this incident. Anyway, I'll file my response.
Contemporaneous records, man.
I'll file my response. Great.
It's clearly attempt to circumvent
that condition.
Well, please come to page 13. I'll just place one paragraph. Page 13, para 15.
We wanted to see the application form. Where is that? Why have you not filed it? You see, the High Court says because he mentioned the details in the other column, in
Yes.
one column he said no.
Yes.
So we want to see that.
We'll disclose that.
You file it, we'll consider your request, otherwise we'll dismiss it.
The FIR as well.
Huh.
The FIR as well, and as well as the stage of the proceedings.
FIR is 498 है.
307,000.
नहीं वो neighbor ने file
Charge
किया
sheet
FIR.
has been.
And the FIR lodged by the neighbor of 498 है.
Aunt of the complaint.
Aunt may be living in the neighbor. Anyway, you file that.
Yes, yes.
देखिए Mr. Vikramjit, Sen Banerjee. No Sen. You are insane.
That's the honorable judge to raise the court.
Vikramjit Banerjee, Learned ASG, has granted 3 weeks time, 4 weeks. 3 weeks time to place on record the application form of the respondent and also the copy of the FIR. Let's start with 3 weeks.
Charge sheet.
So we'll disclose the charge sheet.
Charge sheet also.
Charge sheet.
FIR and charge sheet, तीनों चीज कर दी. Very well.
It's a suit for partition, Your Lordship. So it's a case of divergent finding. 3 courts have concurrently held that it's a self-acquired property. Now the trial court dismisses. I'm for the defendant number 3, Your Lordships. Trial court dismisses. Okay, the suit for partition.
Where is the injunction? Interim injunction granted.
My Lordships,
Why have you not filed it?
that was never served on me. In fact, I actually moved an application before the trial court. My Lordships may say they said that there's no records.
You are appearing in the suit. You file your written statement in 2003, 2004, and 5. You have affected the alineations or the partition, whatever you call it.
Please, Your Lordships.
How is it possible that you are not aware of the interim order? You want to see that order?
That order is not there. In fact, my Lordships may see at page 156. I make an application before the trial court, concerned court. Now, the appellate court only allows a suit for
items
partition.
2 to 8 have been partitioned is because those partition and the earlier partition and the gift deed have held to be transfers
Please, Your Lordships.
in violation of the injunction. Either you place it on record, otherwise we'll dismiss it.
I'll place it on record, Your Lordships.
You place it on record.
I'll do that, but my Lordships may appreciate the fact. The
I
entire
also
case-
have to make that specific government that after the injunction was granted, it was never served upon you and you were not represented in that.
I've said that. I've said that and I placed those documents on record also. I'll anyways place those orders, Your Lordship.
Issue notice returnable within 4 weeks. In the meantime, party shall maintain status quo.
Please, Your Lordship.
Page 110, my lords. Your lordship's order on the 6th of August 2008 says within 3 months these committees have to be constituted in each and every district. I am myself an executive president of the committee in one district I know. These have not been constituted in all the districts in the state.
Go approach the state high court. Now after you are asking us to invoke contempt after 16 years, what has happened in between, what has transpired? Who knows?
My lords,
Any recent communications?
my lords, all the communications have been annexed. My lords, we have been reminding them, we have been requesting them to constitute these committees. Instead of filing a fresh writ petition, our request, my lords, was
And tag with the stray dogs matter.
I appear for the UP officials. Lord, my instructions are that we have constituted both the board as well as in all the districts.
File the reply.
We'll file the compliance affidavit.
So and so has put an appearance on behalf of the
Officials for the state of UP. Lord.
officials of the state of UP. That is respondent numbers.
I think one is
your chief secretary.
Yes, ma'am.
That is why you are here.
one.
One only. Rest को notice जाएगा. इसको भी tag मत करिए, नहीं फंस जाएगा.
I'll file compliance.
हाँ, 4 weeks time to file reply to respondent one. बाकी सबको issue notice and personal appearance not necessary.
Please. Thank you.
May please lordship, item 9 man. And for the past 40, 70 years, I'm in possession and enjoyment of this disputed property. This property was now, my lord, notice was issued that I am the encroacher of the government land, my lord. I have filed a writ petition was disposed of, directed to file an appeal, and my lord, 4 weeks protection has been given. Within the protection period, they entered my property, my lord, lodged a complaint against me, FIR was been filed, and I have been arrested, my lord, sent to judicial custody, my lord. Against which, my lord, I have filed a contempt petition. The contempt petition notice was issued. Counter was filed. Subsequently, explained affidavit was given, in which, my lord, they said mistakenly they mentioned as, my lord, instead of making, my lord, for the spot inspection was to be corrected. Let's kindly come to page number 54, my lord. The petitioner hearing.
Yes.
Page number 54, my lord, para 8, my lord, last 4 lines. But the petitioner herein, with a view to threaten the officials by taking advantage of the error in the complaint lodged by the revenue inspector to perform spot inspection of the encroached area.
You notice returnable within 4 weeks. Personal appearance not necessary at this time.
I'm seeking a password. Take a notice over.
Are you hearing?
I'm in item 10. I am for the 11.
They should notice returnable within 4 weeks.
Please, Lord, I'm deeply aware.
Please, Manas. Manas, in 1928, a private trust is created by my forefathers. I've been residing here ever since. And now in 2011, another clan, one of the branches, they put an eviction petition and I have been ousted. The question
is public trust or private trust?
Private trust.
Private trust. Then, how do you say it is outside the Purview of Rent Control Act? It is within the
Only argument.
That's the only argument and nothing more than that. How much time do you want to vacate?
6 months, Manas.
How long have they been living there?
Since 1968, Manas.
All right, 6 months, very reasonable time.
Reasonable, he could have asked for a year.
Maybe 3-4 years. Nikki, we are not inclined to entertain this.
Occupation as a rent, they will use.
Sorry?
Means property. Okay.
Yes, of course, he will clear all areas of rent and up to date rent for the next 6 months and file an undertaking within 2 weeks that he will hand over peaceful and vacant possession. ठीक है? आप बता देंगे इनको सब? अच्छा, पूछ लीजिएगा. File the undertaking within 2 weeks and 6 months time from today to vacate.
Please, ma'am. My lords,
And
delay of
clear all areas of rent and advance rent for the next 6 months within 1 month from today.
please, ma'am. Delay we can do.
Delay can do.
Thank you. Deeply obliged.
My lords, in item 12, lordships have issued a notice in a similar matter, which is likely to come up on 19th of September 25. It is SLPC number 95625. Lords, I have also filed an application for deletion of respondent number 52117.
All right. Application for deletion allowed at the own risk of the petitioner.
Obliged.
Your lordships, I am the democratically elected representative, and after I get elected, a complaint is filed on the basis of some encroachment that was allegedly committed by my father. But
within 4 weeks.
the stay on disqualification may be granted, my lords, because I am democratically elected and I am terminated.
In the meantime, the effect and operation of the impugned order shall remain stayed.
Grateful, my lords.
Yes.
My lords, I appear in item number 14. At the very outset, I will say that this is an exceptional case, and I pray that the case be treated as an exceptional case, lordship. So we are a medical college. We had applied for.
What relief can be granted to you at present? This is January already. Counseling closed in October.
31st October is the deadline as per this court's judgment.
Lordship, that is exactly why.
And the findings of the inspection committees are so bad as against you that you have unqualified teachers. Infrastructure is not complete. Therefore, better get your deficiencies removed.
With regard to the
And
deficiencies.
for the next session, you start preparation now.
Your lordship, I'll just make two statements. With regard to the deficiencies, they have disqualified the teachers based on the ABAS data, which is their own data, on which they.
Anyway, we can't help you at this stage.
Lordship, why we want the.
Your name matter is pending before the High Court.
Lordship, if the relief is not granted.
You cannot get relief now.
We want to stay on the letter of disapproval, because otherwise
So that is
they have already.
That is already under challenge before the High Court.
Lordship, they have already invited applications for the next academic session.
Next
Now our
case.
challenge is we would be subject
Get
to
your High
double
Court
jeopardy.
petition decided. Next case dismissed.
Much obliged, Lordship.
Petition notice returnable within 4 weeks.
Hello, delay may be condoned.
Huh?
Delay may be.
How much?
36 days.
Condone.
This is after retirement refixation of pay from 2007 to.
What, Dr. Parmeshwar, you are coming here, you are a judicial officer. You are not class 3 or 4 employee who has been paid some extra amount.
Because your lordship said, after.
Return the state money, 3 lakhs and all only.
Returned.
Good.
We have returned it already.
So there is no question of reimbursement of that.
Because we have already returned.
Very good. Yes, we already returned. After 2 years after that, you filed the petition.
Because I tell your lordship.
Correct or not?
I understand. I'll tell your lordships why my concern is this. Because I returned in March 2020. This happens post-retirement. My pay fixation is altered from 2007 to 2020.
All right, next case.
The election results declared.
Item
17.
70 and 64, your lordships.
68.
68. But the election results were declared, the Honorable High Court says, don't give effect to the results of the election. It's by one interim order. Yes.
My lord,
That's the issue.
Now the impugned order is over the writ appeal. Writ petition is still pending.
1 minute. How is the writ maintainable?
My lord, it's for the High Court to decide whether writ petition is maintainable or no. Now this is okay.
on a writ appeal, let's say on an IA that is there. And very interestingly, they move another application before the High Court for vacation of stay. That application is still pending. They can't seek for two remedies for the same.
The single judge declined to grant that stay. You went in appeal.
Please,
And
Lordship.
the division bench has granted a stay of declaration of result.
On election.
Once the writ petition itself is not maintainable,
It did
then
not
where
say-
the question of granting any stay?
My Lordship, it did not stay
Either by the
the
single judge or the division bench.
My Lordship, it did not stay the elections. It said only the results. Now,
Why?
Question is how
Why
it is maintainable?
the difficulty as of now is, in
The
fact,
High Court intervened in
order.
elections.
my Lordship, my difficulty as of now is, okay, the writ petition is still pending adjudication. In fact, the election to the diocese could not have.
If you invite any observation from this court, the writ also goes automatically.
You want to withdraw and go and pursue your writ petition?
My Lordship, now they'll have to withdraw. In fact, I'm on payment.
We will settle
Withdraw
it.
this special appeal, the LPA before the High Court.
My Lordship,
You want to file counter affidavit?
please, Lordship,
Counter affidavit?
I'll file a counter affidavit.
Likhiye. Issue notice. So and so has put an appearance on behalf of the respondent number.
1 and 2, Lordships.
I am for respondent number 21.
Huh?
I am for respondent number 21, Your Lordship.
Achha, 1, 2 and 21.
Please, Lordships.
As such, notices need not be sent to these three respondents. The other respondents may be duly served. Counter may be filed within 4 weeks by the represented respondent. Petitioner will have 2 weeks thereafter to file the rejoinder affidavit. In the meantime, effect and operation of the impugned order passed by the High Court division bench of the High Court shall remain stay.
If I can suggest one thing, Your Lordships, if your Lordships can direct, anyways, they moved an application for vacation of stay. If your Lordships can direct the High Court itself to, say, dispose of the writ
Let's
appeal.
one now.
No,
All right, you said that you are withdrawing your appeal.
My
The
Lordship-
matter will go back to the single judge.
My Lordships, now they moved an application before the High Court in the writ appeal where that's pending.
That
My
will
Lordships
be
will give a
the-
fixed time frame where the High Court will decide on that.
Nothing.
Otherwise, we'll file a reply, Your Lordships.
You file a reply.
Meeting, please, Lordships. Lordships, prosecution has failed to establish the motive in this matter. There.
The SLPs of your co-accused have been dismissed. Javed and Arbaz.
Yes, Lordship.
Yes. You also filed your SLP in 2023. After 2.5 years, you are now pursuing it.
Yes, Lordship.
What is the difference in the case of Javed Arbaz and
You have been excellent.
Your Lord.
Again excellent.
Yes.
So, dismissed. All right. Delay condoned, dismissed.
Grateful.
Lordship's permission, my lord. My lord, it's a case, my lord. We normally usually don't challenge this kind of order before your lordships, my lord. But here the exception is, in all fairness, my lord. This person, he was retired in 2014, my lord, on 31st of January as a public servant. And he was holding the post of additional director in the Department of Agriculture, my lord. He was not the appointing authority. There's a rules attached.
We don't know who was who.
No, my lord, it's born out of record. My lord, I understand. My lord, may kindly appreciate. I understand the real.
You understand everything.
Disputed questions of fact. I understand, but there it is not disputed questions of
There are
fact.
20, 21, 22.
My lord,
There are 20, 21 and 22 of the impugned orders. If you want a proper reasoned affirmation, your trial may be prejudiced. Yes.
my lord, may kindly appreciate one.
Influence of the accused on investigation, every place
My lord,
is writ large on the face of
My
the
lord, that's what I'm demonstrating, my lord. On 3 counts, I have been proceeded against, my lord. That I am the appointing authority. It is a misconception, my lord. I can make out it
You
is.
will be acquitted. Otherwise also you
My
are
lord,
retired.
I am 72, my lord. Each day I'll be going through this ordeal, my
At your
lord.
base only the proceedings must have been state of the trial.
My lord, may kindly
First you
appreciate,
challenge the FIR, you
My lord, may
contested up to
kindly-
this
my lord, may
court,
kindly- my
you
lord,
got
may kindly
everything
come-
said.
my lord, may
Now
kindly-
at the stage of discharge, you've got everything said.
my lord,
And
may-
then you have a grievance at the.
My lord, I am not praying for stay. I understand that I am facing a Prevention of Corruption Act case. But my lord, may kindly come to page 50, 51.
Yes.
Page 51, my lord, para 3.
What is there on 51? Yes.
My lord, the appointing authority, it is the rules. The appointing authority for recruitment.
All
to the
right,
post of
discuss
Road
next
Division
case.
Clerk.
No.
My lord, may I at least allow me to have it represented through learned lawyer in the exemption.
All that you apply before the trial court.
My
The trial court will grant you exemption.
My lord, may
You
kindly
managed to
deliver.
stall the proceedings for fairly.
Next case.
I am not stalling the proceedings.
All right,
my
next
lord.
case.
Thank you.
No. Item? Yes. Why are you here? You are a lawyer?
Yes, my lord.
You have a degree in law?
Yes, my lord.
Why Article 32?
My lord, it's a
You are aggrieved by some domestic violence proceedings against you. Do you have remedy against that? All right.
Yes, my lord, but this order is peculiar in itself, my lord.
All right, next case dismissed.
My lord, at least protection be given, my lord.
Next case.
Protection, DVA proceedings are not, they are quasi-criminal in nature only. Go and appear and that's it, file your reply.
Next case.
If you don't appear, then that will happen.
My lord, NVW has been issued
All right.
Because you didn't appear, that's the reason.
Go and appear and NBW will be recalled. You know that, you are a lawyer. How do you know you are standing?
My lord, I'm afraid the magistrate.
If you are afraid as a lawyer, you are afraid. People are afraid of lawyers today.
It isn't happening there, my lord.
No, next case. All right.
At least protection be given, my lord.
Yes.
My lord, circumstantial evidence, my lord, is entirely case, my lord. The rope, my lord, is a record on the road, my lord. And the
Don't argue this matter, all right? You should have smiled and said, yes, thank you. We get dismissed.
delay,
Delay condoned. Yes.
In this case, prisoner is in custody for more than 10.5 years. Other there were other two co-accused. They have been granted bail by this court by the annexure A2 and A3, madam.
And a distinction has been drawn for your case. Your application has been dismissed.
That was
You are the husband.
That was dismissed earlier, madam. That
So
was
already you asked the matter on
Therefore, my lord, they have been granted later on, and they have been granted, my lord, though husband, my lord, but 10.5 years I have already undergone. 10.5 years already undergone, and my lord, these two have been granted bail by this court. And my lord, ultimately,
your leave is granted in this matter, no?
yes, leave granted, it is admitted appeal.
It's an admitted appeal before the regular
Appeal is pending. Appeal is pending. And in this appeal, my lord, earlier bail was not granted, my lord, but then the co-accused have been granted.
Records against lower court के?
They both have been granted bail.
Record I did not see, sir.
आ सकते हैं? Scan copy लाएंगे? All right.
Listing it for hearing?
Yes.
And it's listing the appeal for hearing?
Yes.
Very good. Well, it's
If we are not
excessively
inclined to
given
grant bail, grant suspension of sentence. IA is accordingly rejected.
Access to records.
The records already received by the registry may be shared with the council for
It's
the
already
parties.
uploaded. It's number 13.
Yes.
So why can't you access them?
Then why do you need to share it?
AOR, I'll instruct the AOR to.
We are asking you when the records are uploaded on the file, where is the question of access or no access?
It's only the AOR who can get the access, so I'll.
दिखा दीजिए करना चाहें करेंगे record may be shared with the council for the parties. Hearing expedited. Appeal may be listed for hearing on 25th February. 25th February.
Grateful.
May I please, Milos? Hearing for the state, Milos. My sincere apologies, Milos. Milos. Last time Milos had granted me time to file some documents from the charge sheet. Some documents from the charge sheet, Milos. So Milos, the additional document which I have filed, Milos, my sincere apologies, there were some dimmed impressions. However, page 1, Milos, of that additional documents. Milos, but page 1 of the additional documents, Milos.
This is regular bill. Regular bill. January से bill में सर्वर हो गया.
No, What has happened to the other accused?
Other accused is in custody, Lordship.
There are two accused, my lords. Both are in jail. One was arrested on 20th September 2024.
Why do you want them still to be in jail?
My lords, the
Charge sheet has been filed? Investigation complete?
investigation is complete, my lords, but it is ongoing since there are other accused, my lords.
All right.
And the main accused is yet to be nabbed, and we are hopeful that he will be nabbed.
So the reason that for past 1 year he is in custody and there is no chance of the trial progressing because you are
It
still
is
investigating the
my lords.
matter.
The IO has been examined, part examined, and the next examination of the IO is on
Trial is
22nd. Trial proceeding, my lords. 22nd January, she is again to. So
Then
let
they
it
can't
complete. Let it complete, my lords.
What? How does it matter?
You are not going to complete it in midst of the trial. You will move an application
Plus,
for
my
snubbing
only,
of the
my only worry is
proceedings.
if my lords may kindly see page number 1 of the additional documents, my lords, there are 23 complaints. As the date the charge sheet was filed, there was 18 complaints against this account number, my lords. In the same day, 35 lakhs has been received and been transferred also, and there are bank statements,
So
my
in
lords.
the other complaints, whether additional amounts are referred to or the same account, same amount is being used for the other 23 complaints.
No, my lords. There are different.
Amount
This
must be the same.
account is used in separate 23 cases, my
Same
lords.
amount,
This case,
same amount.
not same amount, but not same amount, my lords. My lords may kindly see.
Let us know how much amount was actually transferred in this account.
In one of the other cases, my lords, which is evident from the bank statement, my lords may kindly see.
In your chart also, the amount is only 34 lakhs.
My lords,
Stationary at that. No addition, no subsection.
my lords may kindly see page number 5 of the additional documents for the moment, my lords.
Hmm.
In one of the other cases, my lords, 7 lakhs is transferred, and the same day on 16th March 2024, 7 lakh has been debited, my lords, and the balance remains due. Page number 14, my lords. Page number 14 of the additional documents. Total withdrawal amount.
Additional documents is only 9 pages.
And total deposit 3 crores. So the balance remains 0, my lords. So and the mobile number which is seized from him is actually these are all electronic transfers, my lords, through one-time password.
Using his own.
So he is in complete knowledge, and the
Involvement is true. Involvement is well proved. No doubt.
We are only on the question of bail.
My lords, my only submission is that the IO is being examined, and after that, probably the trial will complete, and maybe he will also have to be examined in 13313, my lords. CRPC.
Only on the
And
basis of the
also-
IO's evidence, your entire case hinges only on his evidence. Must be in these cases, who else will give evidence?
And the main accused is yet to be nabbed, my lords. And we are hopeful that he will be nabbed very soon, my lords. My lords, may kindly, instead of granting him bail, may kindly expedite the trial, my lords, for that moment, for that matter.
How many witnesses are there? Charge-sheeted witnesses?
4 or 5 witnesses, my lords, and IO is the last one.
Yes, 6 months the trial.
IO is the last one.
How many witnesses have been examined?
My lords, there are
Only PW1 you have filed on record.
plus that is in
One is the IO.
last one is the IO.
Informants. PW1 is informed.
4, 5 only. Last is the IO.
So IO is being examined.
Is being examined.
All right.
6 months.
Expedite.
Submission with due respect, my lord, he is in custody for almost a year, my lord. All the
Yes, you have gone through that.
Conviction magistrate first class and PW1, my lord, the complaint who has been examined, my lord, he is not supporting the case of prosecution against me.
Acting as a conduit in a cyber fraud.
My submission with due respect, my lord, there is not a single line PW1 complainant is alleged against me.
Doesn't matter,
Your lordship
they
just
have
have
to
to make a statement. And my lord, they are saying
You are
23
working from
complaints,
behind
not a
the-
single FIR is been filed, neither any final report. Your lordship has been pleased to direct on the last date of hearing to the state, my lord.
So we are not inclined to entertain this petition for grant of bail. However, considering the facts and circumstances of the case and the fact that the investigating officer, one of the last witnesses on the side of, from the side of the prosecution, is being examined in the trial, we direct the trial court to conclude the same within a period of 6 months.
Minus.
But in 1 month or 2 months, my
And
lord,
those
only
who are saying that the
not with due respect.
prosecution and the defense shall extend all cooperation in the trial. Very good. Next.
Okay.
20.
May your lordship. In compliance with my lord's direction dated 18 December 2025, I filed chart by way of affidavit, my lord. This will show that the case of petitioner much better than those 6 co-accused persons who were granted bail by different benches of the Patna High Court, my lord. Lord, chart is there, and there of course we have indicated who have the person having granted bail, my lord. It was filed on, lord.
Those scientific objections and also the brief details of petitions have been examined in the investigation describing the role of
6 co-accused persons have already granted. Out of 8, 6 have been granted bail, lord.
Where is the chart?
That has been filed.
When did you file it?
On 8th January, my lord.
8th January.
8th January.
Affidavit on behalf of the petitioner, 8th January.
8th January, my lord. And in fact, in the chart, my lord, I can find some of the witnesses are not even named as accused this petitioner, my lord. And at best, he is said to be conspirator.
Now you are Bansilal Yadav.
I am Bansilal Yadav.
Alias Gautam Kumar Yadav.
Yes, lost perfectly right. And out of 8, 6 have already granted bail, lord. By next P9, P11,
Son of Rambalal Yadav.
13 and P15, including those in Bhagesh,
which he had installed 8 months before and he had handed over to the police.
Yes. Your Lordship, I have 2 objections to what my learned senior has said. First being, Your Lordship, the specific role of the petitioner is not that he was not at the place of occurrence and that he is a main conspirator. He had the specific role is that he had assaulted the deceased, the son of the informant, on the head, due to which the has been caused. Your Lordship, secondly, as per our information on instructions received from the state, 3 accused are on bail out of a total of 8 in the subject FIR.
He has given a chart. He has given a chart. There are 6 accused: Rupesh, Pankaj, Neeraj, Bhageshwar.
Yes, Lord.
Vivesh.
They all have been granted bail.
Either you take instructions on this affidavit filed today.
Please, Your Lordship.
And you come back. If this is incorrect, we will dismiss the petition.
Please.
But if these facts are correct, we will consider this request.
Please, Your Lordship.
Very good. लिखिए the affidavit of the filed on behalf of the petitioner on 8th January 2026 has been served on the counsel for the respondent state of Bihar. The counsel may take instructions on the facts mentioned in the said affidavit within 2 weeks. List again on 2nd February.
As you Lordship.
Grateful, Your Lordship.
Oblige you, Lordship.
Pinging noise.
बंद हो गई बंद हो गई Yes, item number
25, Your Lordships. In this case, Your Lordship was squarely covered by Lordship's judgment, State of NCT of Delhi versus Raj Kumar. In that, Your Lordship also held that in a case in the UAPA, the judgment of Tata cannot be relied upon, and UAPA has a greater scope of extension of time. That is for completion of
There has to be some reason for that. Read paras 24 to 27. What are the reasons you are going for extension?
26 is a wrong finding, Your Lordships. Answer is
Will
page
you
211.
come to para 24, please?
Please, Your Lordships.
Yes. Another 26.
Yes, 26 is a wrong finding, Your Lordships.
Why?
Page 211 is the answer, Your Lordships. Straight away, page 211, para 22. That is my reply before the High Court, Your Lordships.
Para 22.
Para 22, page 211. That the contents of para 43 of the affidavit are not admitted and denied specifically. However, it is submitted in the present matter during the period of 3 months. Total 65 witnesses, including independent witnesses, press reporter, and police personnel have been examined by the investigation officer. Therefore, the OMS middle para and the reply are totally false, misconceived. And in fact, Lordship, why I am saying so is because there was an earlier judgment of the same High Court. So they have simply taken that paragraph from that order, Your Lordship.
Oh, cut paste for the. All right, issue notice returnable within 4 weeks.
And with this delay of 156 days, Your Lordship.
Condone.
I am very grateful, very grateful.
And this comes after notice, my lords. I'm inside for 2 years, 6 months, my lord. There are 70 witnesses, my lords. I'm informed 25 have been examined now. Initially there were 3, but after the others were granted bail, probably they have gone, but still around 45 witnesses are left, 35 witnesses are left, my lords. I'm inside for 2.5 years, my lords. In that time, in the lead matter, my lords. Others were granted.
What happened to the
others were granted bail, but my lords after when my lord.
2 onwards.
Yes, others were granted bail while issuing notice in this matter. My lawyers had asked them to take instructions. Now they have challenged. Stage of trial, my lords, 70 witnesses are there. Out of that, 25.
And as I'll applies my lords at the status of trial.
One second.
So
my lords, there were 3 witnesses.
Today is first time in the new year, so let me want to say something, huh?
So my lords, total 70 witnesses are there. While granting bail to the other accused by the High Court noted that only 3 were examined. That was July 25, my lords, July of this year. So now my latest instructions are, my lords, now 25 have been examined, my lords. Again,
out of 70?
Out of 70, my lords.
And when we granted 2 years time?
That was, my lords, page 91, 92, 15th of April 24, my lords.
4 months still remain?
4 months still remain, my lords. It's not going to get over, my lords.
So wait for 4 months, why are you here?
No, my lords, what had happened actually, why? Because others were granted bail by the High Court, my lords.
So,
my lords, others were granted, so I went to the High Court. High Court said, since this court has specifically said, so we can't do as far as you are concerned. Because Suraj was the main accused, my lords.
Where is the order passed by the court on 15th April?
Page 91, my lords. My lords have that? Page 92 would be relevant. In case the trial is not concluded within the next 2 years, for no reason attributable to the petitioner will be open for him to apply for bail afresh. So what happened, my lords? Others were granted bail, even the main accused was granted bail, that was Suraj. He was in a relationship with the deceased, my lords. I happened to be the brother of Suraj. So when I went to the High Court saying now even the main accused has been granted bail, High Court says since there is an order of this honorable court, so we can't do.
All right, now let Ms. Gilyal make her submission.
So far,
Mr. Mulkan, you are appearing for?
Of the complainant challenging the order passed.
26.1. Granting bail to the others. Yes.
Well, the state has challenged grant of bail to 4 accused persons. 5th one is here because he was denied bail by the High Court. So 5 of them are here. Insofar as the status of trial is concerned, we have cited around 70 witnesses. My instructions are 24 are examined. We will examine around 50. And in terms of my lord's order, the endeavor is to complete the trial by April, my lords.
By April?
Yes, my
Very
lords.
good.
Yes, my lords. Now, insofar as my lords, this accused is concerned, my lords, he is saying I am the brother, my lords, of the main accused. Main accused was granted bail, my lords, on the ground of delay in trial. That's the only ground, my lords. And my lords, despite my lord's order, which had in fact granted us the liberty to finish the trial by April, my lords, that's the only ground on which it has been
After
granted.
this order of 15th April, the High Court has granted bail.
Yes, my lords.
To others,
my lords, to others. Unfortunately denied to him. So that's why he's here, my lords. But despite my lord's order.
Page 102.
My question is,
Yes.
his bail was earlier rejected.
Yes, and
He
my lord
came
said,
here
yes.
on 15th April 24, we said all right, 2 years time. Now after 15th April
Yes.
24, other accused have been granted bail.
Yes, my lords, for delay in trial.
And you did not show this order to the High
My
Court.
lords, my instructions are possibly, because it's not recorded in the order, my lords.
In fact, what had happened since the High Court said in July 25 granting bail to Suraj, only 3 were examined. Probably when the court said only 3 have been examined, there was some.
But the order is in totally ignorance of this court.
But they may not have, well, that's up to them.
How that order can stand? When this court has given 2 years
Well,
time,
that was with regard-
main accused, and what is 2 years in a murder case?
No, but that was with regard to Suraj. That was with regard to Suraj. That was only with regard to me as far as.
Your state's SLP notice has been issued?
No, my lords, it
Not
is
yet.
restricted today, my lords.
For the first time?
Yes, my lords. 4 of them are there.
You have filed SLP on behalf of the complainant
My notice.
with respect to the,
My matter notice has been issued.
Have been issued. Who appears?
That I was on career and I filed my counter affidavit also in that.
That's point number 2, only one accused.
26.1 I have filed my counter affidavit also.
So me clarified.
But state has challenged all 4 my lords.
So total there are 6 matters.
Yes.
Involving 5 accused persons, there are 6 matters.
Malas, others are already on bail. If my loss can just consider.
One more, my Malas, there's one more relevant.
May
May I also mention one more relevant fact, Malas, because these are the instructions I've got. The main accused, Malas, Suraj, has tried to threaten one witness, Malas. Manjula Bain, she has filed a complaint, Malas. She's being examined and there is a complaint filed against him.
Divya Ben is also one, which I have been told.
She was the roommate of the deceased, Malas.
इसमें ऐसा लिखिए इन आइटम नंबर 26.1 सर्विस कंप्लीट है
Yes.
On period है sir.
Let I file.
You are here on period. अच्छा. You have filed a counter also. Complete. So 26.2345 इसमें लिखिए issue notice. So 26.2345 also you must be appearing in one of them, which would relate to
appearing in 26.26 to 26.2.
Ah, 26.2.
For the petitioner, 26.1 and 2 I appear for the respondent.
Very well,
That's the common
correct.
respondent.
Now things are clear, na?
Yes.
So 26.2345 में issue notice लिखिए और फिर 26.2 में लिखिए counsel for the respondent is already present on on candidate. Yeah, you already represented.
You are appearing for Meet.
He's before Suraj. He's before Suraj, my lord. Meet is the complainant.
Let me clear the confusion. I appear for the Solanki brothers, both Yuvraj as well as Suraj. Not anybody else.
Okay.
तो 2 सही है सर, 2.2 में सही है.
So my 26, my lords would consider.
Suraj is 26.2.
Malas, I'll meet the same fate as others if for the time being, if my lords can consider me also on bail.
Yeah, that's a good
You want
analogy.
the
Yes.
stayed?
I'm
Bail
sorry,
orders to be stayed.
I'm sorry, my lords.
You want their bail orders to be stayed?
No, I'm not. I'm saying that
There is a precedent. There is a precedent from Gujarat only.
That order only Ms. Gildial could have got. तो 26.345 में नोटिस जाएगा फिक्सिंग 2nd February 2026. Does the service permitted to the state? List all these matters again on 26th February, or on 2nd February.
And item 26, my lords.
All matters.
My lords may consider me, my lords. Others have been granted bail, my lords. Even the bail accused Suraj, my lords, has been granted.
I'm coming back to you, don't worry.
No, but my lords, kindly appreciate, my lords. He was granted 6 months back, my lords.
Next case.
Please, ma'am.
Well, I've just happened to be the brother. Well, he was in a relationship.
All right.
Very well. I'll leave it to my lords.
We have not received any counter in this matter. State was about to file counter.
Yes, I'm seeing a short pass. The main counsel is in code number 8 right now.
You want time to file counter or you want
The
for
counter has been filed on Friday. Only we received the report on
Friday.
Thursday, and same is not on the record today.
Allow me to give my appearance. I forgot to give my appearance on that.
All right. Physical appearance acceptable.
We have not received the counter.
Same has been filed on Friday, and same is not on the record.
Counsel for the respondent says that he has filed a counter affidavit only on Friday. However, copy of the same could not be provided to the petitioner. The same may be provided today itself.
Yes, madam.
Office may trace it out and place it on record and also upload the top copy. Petitioner is granted 2 weeks time to file rejoinder if any. List immediately after 2 weeks.
Yes, madam.
May it please, my lords. My lord, this one, my lords, I am inside for, my lords, 4 months. This was actually a case of accident, my lords. This has come up 3-4 times earlier, my lords. I happen to be a chairman of a Samalpuram town panchayat, my lords. Why would I go in the evening? There is no CCTV and hit a person, my lords. They say he is a human rights activist, but I'll go in the middle of the day, my lords. You don't require me for any investigation. Please have a look at page 22. The man was sick. He was not wearing a helmet, was having a registration. It is my political opponents who want me inside bar. My lords, they have got that someone has passed away.
Let us see what the state has to say. Yes,
Your Lordships, I appear for the
Witness confirmation dated so and so, Annex P1, where under the adnote of arbitrator, it is stipulated that inverted commas, in case of any dispute, dash our A capital, our comma brokers B capital, decision shall be final and binding on both parties, that is seller and buyer. inverted commas close, you run exactly on page 27. As per that. In our considered opinion, the contention whether the aforesaid clause amounts to a binding arbitration clause or not, is also an issue that can be effectively raised before the learned arbitrator appointed by the High Court, who is a, is it the same order where Justice Saeed has been appointed?
Yes.
The former Chief Justice of the High Court has been appointed by the sole arbitrator. Mr. With liberty of mention, we see no ground to interfere with the insurance of the arbitrator.
I am grateful, my lord. My lord, delay may be, there was delay, my lord. I am grateful. Grateful.
Your Lordship, these are LAR matters. Your Lordships has already issued notice in similar matter.
Use the mic properly and use your voice also very forcefully.
Your Lordship.
How you can argue?
Lordship, these are LAR matters. The plots were acquired for Thiruvananthapuram International Airports. So what we pray is our compensation be enhanced to 15 lakhs per hour. As your Lordships enhance it to 15 lakhs per hour, and your Lordships can see order.
Why it should be announced?
Your Lordships, these are very simple, illiterate people. They do not, they're not planning to lead a luxurious life with this. But what they got before the High Court, that is very less compared to what others in
the place. Why should it be announced to 15 lakh only? Why not 18 lakh? Why not 20 lakh? And why not 14 lakh?
Your Lordship, that is a fair amount considering the area.
But next time, suppose you say, no, fair amount is 18 lakh. Last one, previous date of hearing, I was wrong. I had wrongly said 15 lakh. Then where to find out?
Lordships, whatever your Lordships think.
So should we record that you will not claim more than 15 lakh?
If your Lordships think so, your Lordship,
or if suppose we find that the land is of not less than 25 lakh value, are you going to give up 10 lakh rupees per acre? What does the law say on this point? We are also sometimes confused. We don't recollect every settled legal position. Sometimes bail matters, sometimes land acquisition, sometimes lapsing, sometimes we had seen PIL. What to do? We also forget the law. What is the legal position if the court finds that a landowner is entitled to, or forget for the landowner, if the court finds that the market value of the acquired land should be, say, A amount, but the landowner has claimed less than that, only B amount. Should the court confine that claim only to B, or the court can even go beyond what is prayed before the court?
so I'll have to come back on this.
All right. We are issuing notice so that you can study further. Issue notice, return over and so on. Are there some other matters pending? See, there are some matters pending. So, tag with your and fix the same date.
Lordship, there's a delay as well.
There are this matter to each matter. बच्चा पीरो
Nine, I'm requesting for passover answer. Requesting for passover, I'm led by Mr. Damasha Shadri Naidu.
Passover?
Your Lordship, hold down. No, I'm sorry. I'm so sorry. I was sitting here for item number 10. Along with 8, I think this was to be taken up. In these cases, your Lordships were pleased to issue notice. My Lord's judgment is also there, which I have placed as annexure. In all these cases, your Lordships are listed for final disposal sometime in the month of March, or I think March, yes.
So what we want, we have issued notice only. If you want us to allow, we can allow it today itself.
I'm so sorry, my lord. Item 10 also, your lordship may be pleased to issue notice.
All item notice issued.
Obliged.
But you are for the state only.
No, I am for the council, my lord, for the petition only, my lord. In all these cases, I am for the petition only.
Oh. We thought that we are appealing for the state now.
Pardon me?
We thought you are appealing for this.
No, I am so sorry. I am for the petition.
No discrimination with you also, notice issue.
Well, will be tagged with the other cases.
The young girl has argued very well, so we issue notice in all the cases.
Obliged, my lord. I am very grateful.
$5,000 something days delay.
That's it. That means your lordship may not grant any interest for that delayed period. That
the argument will be that since we have already granted a set of compensation, we can't, the court should not discriminate and every landowner should be held entitled to same compensation. So then our argument would have been, why were you sleeping where you had gone for all the...
What about 28 capital A?
28A. Then your argument will be 28A. What is the legislative policy of 28A? 28A, in fact, is a replica of Article 14 in a way.
That's it.
Through 28A, Parliament wanted to communicate that there should not be any discrimination in the matter of grant of compensation only because someone did not approach the court through the regular channel of first appeal or so.
Obliged.
And then the next question will be, should we condone a delay of 1,000 days and thereby subvert the statutory limitation under 28A?
That is why I am submitting.
No, we are not asking you. This young girl will have to answer the question. And you will find there are judgments by us, very routine judgment, not very historical judgment. These are all smart, short orders only. You will find an answer to that question also.
One judgment I have placed on record as an issue to my petition.
Thank you.
9, I'm requesting for a passover on us. 9, I'm requesting for passover. I'm led by Mr. Damasha Chadri.
Yes, you are. तो ये भाई को तो कोई देना पड़ेगा. For the limited purpose as to why the matter be not relegated to the High Court for adjudication on merits. I'm sorry, Honorable on so and so forth. So,
well, there's a
ओमकारा इलीगल हाई कोर्ट में कोई आंध्रा भेज देते हैं कोई तेलंगाना उसके लिए कुनूर में कोई बेंच बनानी पड़ेगी इसके मैटर की.
So we have come with a permission and delay. Lordships have already granted leave in the matter. At page 281 is a Lordship's order.
But Mr. Agarwal, why are you coming now?
Because only after 2024 we were issued eviction notices. We have put it with additional documents on record because no other parties before the High Court. Lordships will recollect this is that Uttarakhand matter where nobody was a party. All SLPs are with.
Where are the eviction notice now issued?
2024. 2024.
2024 also.
Yes, Milos. It is little belated, Milos, but Lordship will just consider page 2302, Milos.
That will be the other matter.
Milos, that date your Lordship's last was is a regular hearing matter, so now it will come in the regular hearing list, Milos. It was earlier put for 10 December, but I think it didn't get taken up.
He says the first notice to petitioner is in 2017 by the estate officer.
Not 17?
250. Page 250.
250.
Yes. 2017 notice.
No, these are.
These are estate officer notices.
These are not notices to us, Milos. See, Milos, what happened?
This is petition number 14, sir.
The large, yes, Milos, large number of people, large number.
Your other similarly, or purportedly similarly situated persons, they filed a writ petition, they filed intervention application, nothing, you did not take any step.
Right.
Notices were there.
And we have very serious doubts about the existence of these people and that they are bona fide living there because there is a.
No, Lordship, because there were the reports of, there was report.
Aishwarya would say, he's standing there.
Sorry, Lordships are looking.
Where was Surya? That Haldwani matter.
Yes, come from.
We have very serious doubts of bona fide of these petitioners. Fresh petitions are coming. Who are they? From where they come? You need to verify it.
Yes,
We are simply tagging it. We are not issuing.
I'll give a copy to my
Who is assisting you in that matter?
Manat, I'll give the name of the advocate on record, Manat.
Let a complete set of paperwork be handed over to so and so. They are who is assisting me as per your additional Solicitor General, who represents. You are appearing for railway or for state in that matter?
Manat, I appear for railway and Mr. Abhishek Atri appears for the state.
Maybe
Mr. Amrish Kumar will accept notice.
Maybe delivered in the offices of Madam S.V. Bhatti and so who are presenting the Ministry of Railway and State of Uttarakhand respectively.
Grateful.
The that we tag with the notice so and so so and so.
Grateful. Obliged.
Well, my lord, I have issued notice in similar matters, my lord. These are coming up on 23rd February, my lord. 23rd February matters are coming up, my lord. We'll issue notice on delay also, my lord.
Further announcement, issue notice considered by this facilities on.
Please, my lord.
My lords, the State Tamil Nadu Judges Association is a petitioner before my lords. My lords have clearly.
Survive in the light of the constitution.
Well, judgment, have you seen?
Yes, my lords. In fact, our submission is that the act of the High Court is in grave violation of my lord's 5-judge bench order in 2020.
No.
Two aspects were clearly set out by my lords. One is the ratio of 50:25:25, and secondly, the roster, my lords. Here, instead of 3:1, my lords, where there should have been a ratio of 3, only one judge is located.
There cannot be any ratio at all.
Now, after the question of ratio,
district
The lords
judges.
have clearly said the roster should be first RPs, then the.
No. We have forget all those rosters. We have the direction in the Constitution Bench last decision is to review all these orders and make new rules in sync with the directions given.
Millards.
So there is no roster any further.
No, in fact, the last para, if I may read it, para 100, we filed a compilation, Millards. And the Lords have summed up what has been captured in the judgment. The compilation at page 16. The first is at para 4. That the data put forth by so and so for HSC. Which is natural since the ratio is 3/4 of the total posts of the cadre. So here and as well as at para 13, my lords affirm the 50:25:25 ratio, my lords, and lay down a.
That is the entry point. That is the entry point.
that is for entry point.
Post entry point, no list.
Every year, my lord say it should be 50.
Zone of consideration.
In the zone of consideration. And at para 10, my lords have laid down the.
No, please don't miss this to the.
My lords, our only submission, my lords, is the same aspect which my lords have stated is what is captured in the GO of 7/10/2025. All we are saying is that 7/10/25, if my lords are saying that the 7/10/25 GO should be reviewed in line with my lord's order, that may be captured, my lords, but there is a connected matter also, which also
reviewed, madam, because of Roman 14. And paragraph says 100.
Yes, my lord.
The sub-classifications we have held cannot be permitted.
My lord,
And it becomes a common cadre. So it becomes a common cadre.
birthmark aspect which
Yes,
we captured, my lord.
And we are not confused because one of us is the author of this order.
My lords, my lords, I am aware, I have noted that. My lords, my only request or submission, my lords, is that on 3/11/2025, my lords will find it at page 64 of the compilation, a connected matter which also raises an issue.
No, no, sit down very well. We'll discuss that also. We don't want,
issued notice of.
we don't want any confusion. We'll dispose of that matter also.
My lords, then the issue then arises, my lords, now subsequent to the filing of this writ, multiple recommendations have been sent by the High Court without complying with the five-judge bench order of this honorable.
That has nothing to do.
All of which have to be reconsidered.
This document has nothing to do with recommendations. This is only pertaining to resolving the as usual intrinsic disputes of seniority.
My lord, that recommendation necessarily has to follow the directions that this honorable court has laid down.
This also, madam, has been taken care of in the constitution bench judgment, saying that what has already water flown under the bridge, we are not going to.
My lords, but that's
the thing.
Recommendation is subsequent to my lord's order. My lord's order is of 11th November 2025.
They were all in the pipeline then.
Done in.
The recommendations were in the pipeline at that time.
My lords, but it would not be fair to the parties. The All India, the state Tamil Nadu Judges Association is before my lords. It is not any single individual judge who is before my lords. All that the association is asking.
They are completely misconstrued the judgment, then what can be done?
Complied with. My lords may direct that the order of this court may be complied with in the process of recommendation.
They are bound to, everybody is bound to.
Any GO that the government passes, my lord.
In view of the self-explanatory judgment dated November 19, 2025, passed by the Constitutional Bench of this court in IU number 230675/2025, in repetition serial number
November 11, 29.
The instant petition cannot be entertained.
My lords may consider tagging it along with the other.
The same is cannot be entertained, being misconceived. However, the High Court of, however, the Madras High Court will ensure that the directions contained in the above cited judgment are complied with in due course of time.
My lords, and with my lord's leave, there is an error in the prayer clause. Is that correct? Like.
My lords, the state is before your lordships, my lords. State of Telangana is before your lordships. The difficulty is, my lord, that this was a land which was given to landless laborers as a
One shocking kind of. High Court has, of course, unfortunately, didn't even understand what Manohar Lal said. But what is your conduct also against it?
My lords, we resumed this land in 1997 for our irrigation canal.
No, despite the repeated directions by the High Court, you are not paying compensation.
My lords, we paid, they refused to take, my lords.
No, we paid when?
2017.
17.
Yes.
Of an acquisition of?
My lords, 97 we had resumed the lands. Because, and as per our stand at that time, my lords.
You took the possession 1989.
My lords, 1989 we in theory decided to resume. In 1997 we have formally resumed and the irrigation canal is made.
Well, at that time, our stand was because they had not put the land to use for cultivation, because these were lands that were allotted, assigned lands. So we simply resumed them.
You had acquired the land, and when the land is acquired, it is always as is where is basis. State can't say that I'm acquiring your property and you convert the land like this or develop the land like this and then I will acquire.
I bow down.
You had acquired the acquisition at the finality. Despite two rounds of the litigation, despite the directions issued by the High Court, your officers are playing mischief. There are some dishonest officers who must be involved in something that you are not releasing them compensation. And ultimately you are inviting an order which is palpably illegal order. But the High Court seems to have been fed up with your conduct also.
Resolve it before your lordships, my lords.
Whatever your lordships will apply in this case. Are you appearing?
Yes, Your Lordship, I am for the caveat, Your Lord.
For God's sake, how 24-2 will apply in this case?
For 90
We are sorry to say the High Court judge, they don't even understand what the Constitutional Bench has said. Or they don't want to understand.
contempts were filed, and every time whenever contempt petitions were filed, they had given an undertaking that they will deposit the compensation amount. But till date, no.
Issue notice, then so and so accepts notice on behalf of the respondents. The meanwhile, operation of the informed judgments of the High Court shall remain stayed. Or the state of Telangana is directed to release the compensation as was determined under the old act, along with interest at the rate of, what is the statutory interest? 34.15%.
What we had decided, Malad, at page 62 was that first year 10% interest, then subsequent years 15% interest.
15%?
Yes.
Along with 15% interest payable with effect from the date when possession was taken on 2nd January 1989. The compensation amount along with solution and interest as directed above be deposited the reference code within 4 weeks.
Please, madam.
Within 4 weeks, the respondent landowners shall be entitled to withdraw that amount unconditionally and without prejudice to their rights for further enhancement.
Grateful, Malad.
Much obliged. I do oblige.
Very grateful.
Please, my lords. My lords, the allegations were, I'm sorry, my lords. Can my lords hear me?
Yes, yes, yes.
Please, my lords. The allegations were of 2016. I got acquitted in 2019. I was restored to service, but then have been made to rot there because in 2020, immediately disciplinary proceedings on the same set of facts.
Mr. Agri, now the judgment says clearly that inquiry's complete report has been submitted. So we can only...
I'm sorry, my lords. The report has been submitted, but there is no action either way. And I'm sorry, my lords.
We will request the administrative committee of the High Court to take a decision as early as possible, and we will fix a timeline for that. So,
please, my lords.
The petitioner is a judicial officer who earlier faced a criminal trial in which a criminal trial under
Your lordships may omit the sections.
Oh, like even I wanted to omit to that, brother, delete it. First, a criminal trial in which he was eventually acquitted. While judgment dated 4th May 2019, passed by Additional Chief Judicial Magistrate Ali Purdar. Though that judgment attained finality, however, the High Court resolved to initiate disciplinary action against the petitioner. He was placed on suspension, followed by a charge sheet. The fact remains that now the disciplinary proceedings have been concluded And as per the implement judgment of the High Court,
The report has been submitted. Proceedings have not completed.
the inquiry officer had submitted the report on 17th March 2025. Mr. In such circumstances, we deem it appropriate to dispose of the specially petition without expressing any opinion on the merits, with the request to the administrative committee of the High Court at Calcutta to take an appropriate decision on the basis of the above stated inquiry report as early as possible and preferably within 4 weeks.
Please, my lords.
Preferably within 4 weeks. Disposed.
Your lordships may also note that I am due to retire next in 2027. Your lordships may just make one line in that.
Also, when the petitioner is due for retirement on superannuation next year.
Great.
Just do the month also, Mr.
My instructing advocate, Mr. Kargupta, will give the court master that, my lords. I am out of date.
Insurance. Due for retirement on superannuation in the month of Swans.
Grateful, my lords.
It pleases court. But the High Court finds, prima facie it is arbitrary, doesn't get into the merits of the matter, no counter called for, because it's in the teeth of the NGT order. They set up one person. The competitors set up one person to file an application.
Just versus private interest, what should we do?
Well, it is not public interest. There is a finding rendered by the NGT. Got it.
Okay.
That's there should be a stay of the because in the teeth of the NGT judgment. The NGT judgment on 10th says, Milods, that you will not give it to anybody except in the view of the CPCB guidelines within 12 days without reference to the NGT judgment. It was a party to the NGT judgment, page 342. The order of 22nd October 2025, it is at page 347, must be stayed, Milods. Otherwise, they will now start allotting in violation of the CPCB guidelines. 347 is the impugned order before the High Court, where they opened it up for anyone in violation of the CPCB guidelines. 347. It's in Hindi because the English translation is bad. 22nd October 25. Sorry, volume 2.
Meanwhile, no other entity shall be allowed to operate for collection of biomedical waste within the territorial area demarcated for the petition. Without?
Very well. Very well.
The CPCB guidelines.
Without complying with CPCB, that's good enough. Grateful.
Yes, item 14,
Please allow. So principally, my prayer is based upon the Article 14 proposition, my lord. One person, one vote.
These are known as whole as the efforts to stall the election.
Local acts.
2016 amendment now is
No, thereafter 2019 amendment there, my lord. There is a 2019 amendment, then that, thereafter then there is a 2024 amendment. Lord. And section 5(3) has been amended, my lord, because there is no uniformity.
Why not you introduce some cost factor for forcing us to read this kind of petition? We are forced to while traveling.
Wait, I discussed with the client, but sometime I have to go with their choice. I'm blessed.
We got similar case paper. Continue lower in schedule.
Did you date any idea?
My lord,
There is one matter issued office.
Similar matter, Ram Shankar Prajapati.
that is my lord, 682, 2025.
382.
682. This is the order.
I was a petition civil number 682 of 2025. Same as you could just here.
My lord,
Ashwini sir.
this young boy has not drafted a petition. Please allow me.
We are fixing for this only.
Obliged, madam?
Both the matter will hear together.
Obliged. Right. Lordship have issued notice in the 19, my lord.
19 is different.
19 is different, my lord.
ये भी दूसरे पद है, एक नए पद और एक पद है। अभी लॉक किया नहीं है, इनको पीआईएल का शौक पड़ गया। पढ़ते क्यों नहीं हो जाते घर में?
Please allow me. It's a fantastic petition, my lord, on the right to health. Just allow him to argue this case, my lord. He has drafted this petition.
He is your son.
I refer to him as sir in professional capacity.
But you,
Yes, sir.
Just allow him to.
Study coming to Mr. Pajay, what are you doing? We thought he will pass out with some gold medal and go for good education because his father can afford. And then of course he will be a bright lawyer of the future lawyer of the bar.
He has completed the 15th volume of the DD Vasu, my lord.
That's it. Very good.
So it's a very important matter, my lord, because this act, my lord, at that time when the act was enacted, my lord, that we don't have the Ayush Ministry, we don't have the Ayush doctors, my lord, we don't have the Ayush Commission, we don't have the National Ayurveda Commission, my lord. Presently, my lord, this act need to be, it's a 7.
Drug and Cosmetics Act takes care of this. Any Ayurveda, Unani, or any Indian system of medicine, you are qualified, you can give advertisement.
No, what is happening, my lord, this DMR Act was enacted in 1954.
Right.
It allows the MBBS doctors to mention what they can cure, but it restricts, because at that time there was no Ayush doctor, there was no.
MBBS doctors, sir, are subjected to greater restrictions on advertisement than what is given to you under the DMR Act. Section 14 exception, you can say what treatment you are doing. But what you cannot do, you cannot advertise for a drug. You can advertise for a drug only when that drug falls in the schedule of treatment under section 2A of the Drug and Cosmetics Act about Ayurveda, Unani and other Indian systems.
This is the one page short note. If please allow me, permit me to read it. This is the one page short note, my lord. On this item 19. Please pass in. It's very important matter, my lord.
This point of returnable on so on.
Would like one.
For your son.
It's only to encourage him. But to encourage him not to file PIL, but to encourage him to concentrate on it.
Yes, yes, my lord. Would like.
Your Lordship may kindly pass over.
Item 20?
20. Kindly pass over.
should go to the High Court with that. Who is to argue?
Senior advocate R.S. Malik.
Senior advocate?
R.S. Malik.
रामेश्वर मलिक चंडीगढ़ से लाए हो। हाँ यही प्रैक्टिस करते हैं, रिटायर्ड हो जाते हैं, एक्चुअली चंडीगढ़ तो कर ही नहीं सकते। हाँ मलिक साहब बुलाइए, हाईकोर्ट जाओ, अपना वहां फाइल करो केस को।
सब आगू करेंगे कि हम वही
1821.
Yeah, please, Manoj. Manoj, the primary challenge is the word deliberate. Manoj, there was a reason. And the reason was, Manoj, we had come against the interim order before this court. And that was the reason that replies were not filed, my lord.
Why do you expect a special treatment to?
No special treatment, Manoj.
30,000 cost.
My lord, 30,000
is the expenses for filing an SLP to the Supreme Court by the Lord Ministry.
My lord, I
To avoid 30,000 costs, plus Union of India expense more than 50,000.
30,000 is not an issue, my lord. I am not here to waive 30,000, my lord. Primarily, it is the word deliberate. That, my lord, in circumstances when we were facing a lot of, my lord, we had come here. Thereafter, my lord, actually, my lord will understand from this. There was a person, my lord, who was not there. We had put a notice in his house and said that you will come and explain. That is all. He went to the High Court, my lord. Later on, my lord, we have already withdrawn that notice. We had already withdrawn that notice. 2 writs have already been.
Which notice have you withdrawn?
Two writs of one person, my lord, called, this is Vikram Ravindran, have already been dismissed as infructuous, my lord. We have withdrawn the notice ourselves. Because we never had the occasion to.
In the matter in which this cost of rupees 10,000 multiplied by 3
10,000
imposed, that matter you have withdrawn the notice.
Yes, in 2 of the 3.
Out of 3 matters.
Because he never come, my lord. If the house was closed, we had put a notice against which he went to the court.
No, well, which item numbers?
My lord, it is a comprehensive this, but the 2 writs which were 72 and 73 in High Court, my lord, against which is a common order we have come in one single.
72 and 73?
Yes, my lord. My lord, I am carrying the order, my lord.
Only 10,000.
My lord, we are only against the deliberate part.
But usko do deliberately.
If my lord,
serious objection if the word deliberately is deleted.
The third round of litigation, that's it, my lords. Subsequent proceedings have been challenged before the court. My lords can see the office report.
So
everything has been challenged before this court. My lords,
leave granted. Hurdle on Judicial Solicitor of India on behalf of the appellant as Enforcement Directorate and also appearing on behalf of the respondent on previous. With regard to the fact that the notices which were challenged in Reputation Criminal number 72 and 73 of 2025 before the High Court of Judicature at Madras, were subsequently withdrawn by the Enforcement Directorate, coupled with the fact that it was at best a case of an administrative delay in filing of the counter affidavit, we allow these appeals in part to the extent that the observations made in para 2 of to the extent that para 2 of the impugned order is set aside, and it is held that the posts were imposed by the High Court on account of the delay happened in filing of written statements. What is counter affidavit?
Yes.
A counter affidavit due to administrative reasons.
Yeah.
Well, item 22, similar matters your lordship has already issued notice. I have filed all the special leave petitions pursuant to your lordship's last order.
I wish to say something. There are two types of cases below. They are not all identical. You lordship will find the distinction at page C itself. Turn to page C. Page C below. Page C of the list of J. C for Calcutta. The lordship will find they themselves have said two categories of cases below. First category is the one where lordships have issued notice. Where below the allegation is mining outside the area granted by the EC below. All the other cases are different where they say, my lord, that there is a sand which has been sold without a challan, etc. Now, in regard to these cases, the current SLP now relates to category 2. Now, what has happened is, my lord, I surrendered the lease. If your lordship will turn to page 87, this is completely different from the first batch of cases. If your lordship will turn, my lord, to 96. In regard to the second batch of cases, my lord, post my surrender of the lease, they have started selling my sand, my lord. Just turn to 96, my lord. The lordship will find on the top a criminal prosecution which is not even disputed. So what is not disputed? Kindly turn to bottom, my lord, Roman 5. Immediately after surrendering, I surrendered, my lord, pending, my lord, the lease because it was not, because, my lord, of illegal mining going on, nobody was willing to buy, my lord, my lord, lease. Item 4, petitioner surrendered the lease on 1st of May. Immediately after surrendering, creation of e-challan was stopped. The reason behind was that settlement was not financially viable due to COVID and the ban of so-and-so. All sand guards were taken back by the authorities, were handed over to the local police and circle officer in Bhojpur and Patna for care and protection. When petitioners surrendered their settlement, the authorities concerned raised a demand. From letter of so-and-so, it appears that the government started selling the land from my sites, my lord, which I have given over before lodging FIR.
You see, admittedly, vice of surrendering the site and then continuing with illegal mining.
In the both type of
cases, no, sorry, my lord. I have not done any.
This 28 crore odd amount was for the period even before the surrendering of the license.
No, my lord, with great respect. Just see a little further, see at 86. There is no allegation of illegal, my lord, mining.
The High Court has travelled into all these questions of facts.
Lord, it is, if your lordship sees, my lord, this is their own letter that they were selling my sand, which was lying there, my lord.
Notice. Counter affidavit we filed. Counter affidavit can be filed within 2 weeks. No further opportunity shall be granted. Post the matter also there.
Lord, may I submit the list of entire cases to be listed together? List of entire cases to be listed together.
All the cases. All that are listed or?
All the cases are listed. 5 cases notices have already been issued. I have given the list of all 35
cases.
That's it.
19th of January. I have issued notice in these matters also 19th January.
My lord, your lordship will give me 3 weeks for counter. Because they separate cases, my lord, I have to find separate.
No, I think one case you can be counter affidavit can be filed in one lead case.
So there are 2 separate types of cases, my lord.
Sometimes the judgments create a lot of problem for us. If you want, we will set aside it right now. However, please file your counter within 10 days.
May
Judgments, why the High Court becomes so over enthusiastic in interfering in this kind of matters?
Item number 22.2.
The counter affidavit can be filed by the next day. No further opportunity shall be granted.
Lord, may I request, Lord, may I invite you to attention? Diary number 6. Item number 22.2 is a bail matter.
where, my lord, they are seeking cancellation of my regular bail granted in November.
Case of blatant misuse of concession.
No, but may kindly
Resulting in all kind of things.
arising out of the same complaint, allow me, my lord, to pass on this order, arising out of the same complaint. My lord, in fact, they are coming for cancellation after more than a year. I have been granted regular bail. And co-accused, who was an accused in the main complaint, they came up before this honorable court seeking cancellation. This honorable court passed a detailed order, dismissed it, saying that this is a complaint. Now the predicate offense, the trial has been stayed by High Court. In other connected matter, the FIR has been quashed.
Application for transferring of these trials.
My lord.
You file an application for transferring these trials. We'll shift these trials from there.
My lord.
If they are interfering in day to day, sometimes they quash the FIR, sometimes they stay the trial, sometimes they do. What kind of impression they want to give?
So far as bail aspect is concerned, because this honorable court has passed an order dismissing cancellation in the co-accused, my lord, who was an accused in the main case. Allow me to pass on this order, my lord.
We will see on that.
Yes, your lord.
Lord, may I request that diary number 63426 should be treated as a main matter, because this was the main matter before the High Court. Diary number 63426.
Number so and so. And the same can be adopted in the other connected places also.
Your Lordship, I am in 22.1, 22.8 to 22.17.
Whosoever is appearing.
Yes, I am for the response. I am accepting notice.
Lord, the bail may be detagged then, Lord, because quashing is different than bail.
Not detailed, but you list them separately. On
Yes,
the same,
separate.
but list them separately.
Yes, sir. 22.2. Grateful.
Item 23.
I'm seeking a short pass over my lordship in item 22. Short pass over my lordship.
Also, what is that constitutional interpretation issue raised in this matter? If you are wife, you have 2 children, you have to maintain them. That's all. If you don't have income, you generate the income. And you can't generate the income, then go and get arrested. Then enjoy this hospitality of the state. That is the only way.
Short password may be given the learned counsel to assist this honorable court, my lordship. A short password may be given the arguing counsel to assist this honorable court, my lord.
Next.
I've placed the order of the trial court on record to an IA. The witness continues to be unwell. I've placed the order of the trial court in IA on record. On 3rd December, this court had directed that the witness should be examined on 12th December, subject to his health. And also the trial court was guided to explore other possibilities of examination. On 12th December, the witness continues to be unwell. And if the court would just see page 8 of the IA, which is the 12th December, the last page, he'll take 8 more weeks. So the court has decided to summon him after 8 weeks. So 12th December, 8 weeks would fall in February.
So after 12th December, now what is the date?
12th December, the date is now the following week, 20th January, for other witnesses. So the dates have continued for other witnesses. Because the initial order of this court was for protected witnesses to come. So the trial is continuing, but my witness, who is not protected,
that witness is still hospitalized.
He is still unwell. As per the report, he is unwell. He'll take time to recover. So the court would see the order of the trial court. The trial court
will appoint a local commissioner.
That's what on the last order itself that is clear. I think the court has to now pass an order to that effect.
And the last
that has been done. That observation has been
That
done in
observation
the
was
previous order.
record. The court did not note anything in its order, but off the record, the court was inclined to first ensure he is healthy and then take whatever steps are required. There's a line.
How do you want? You tell us, because your interest as an accused is more important. Do you want him to be examined through court commissioner, or you want him to come in the witness box?
My preference is he comes in the witness box. It's also because this is a conspiracy case. I'm charged for section 18. There are some 20 odd co-accused.
Then we can take one chance that if he comes on
after 8 weeks
for the date fixed. Otherwise, also think of, suppose sometimes there is unfortunately some spinal cord issue, or some doctors don't allow him to move. We don't know what is the reason, but we are on a hypothetical basis. Then court commissioner with full videography can be done.
Very well. Very well.
To protect your interest of cross examination, that can be done. We also find out Mr. what is the position. So we are informed that the witness who could not be examined on 12 December 2025 due to having been hospitalized for my still unwell and has not been brought to witness box. The other witnesses are summoned for, what is the date?
The 20th.
Summoned for 20th date.
20th of
Mr. Nityag Lange, Additional Solicitor of India, promised that he will find out about the latest health condition of the witness and as to whether he can be brought in the witness box or his health condition is so peculiar, he will have to be examined through a court commissioner. And suppose so date. We can fix it immediately next date of beyond the trial court date.
So the trial court date is 20th of January, but as per the trial court order, 8 weeks from 12 December is when he'll be summoned again. So I would request if it in March it can be fixed. By that time, we will know once and for all.
In the meantime, other witness examination can give.
That is continuing.
Meanwhile, other witnesses in any case be examined without any delay.
So I'm praying, making two requests. Out of settlement amount of 3.15 crores, 1.90 crores stand paid, Millets. Now, two requests I had, Millets. One, Millets, 25 lakhs will be transferred to my colleagues' clients' accounts by Friday, Millets. And the remaining 1 crore by 30th March, as was the settlement agreement. 31st March, as per the settlement agreement. So this, your lordships may consider and posting the matter to April so that the payment is made, Millets. So two by Friday, 25 lakhs and 1 crore by 31st March, lordship will have it in April. No, just one request I have. So I've been requested my learned friend to give me a copy of the valuation report. So they were to get it valued, the shares, and they had to pay the tax. The amount they have already given. The report they have not been giving. Just if they can hand over the copy of the valuation report.
Once there is a settlement, then at least you are in a better position to dialogue with each other.
I have been requesting somehow I didn't receive
Let the money come, lordship will sort it out. We have given 34,000. If my learned friend says it is less, suppose it's 40,000.
Because I am not saying it is more, it is for the income tax authorities to decide.
Yes, so they will
I just
decide.
want the valuation report so that I can give it to the authorities. They have not been giving me the report. That's the issue.
Let us stick to the settlement. Anything will be difficult. Lordship may just have it in April. Let's the money come. Then we're grateful to your lordship.
Director of your notes. Petition for bail, my lords, the allegation in the charge sheet at page 111 is that the petitioner A2, my lords, had participated in the recruitment of members, my lords, to the cadres of the PFI. The FIR, my lords, is dated 19/9/2022 and petitioner was arrested on 22/9/2022. PFI came to be declared unlawful, my lords, thereafter on 28/9/2022. So this is the bald allegation, my lords, at page 111. There is no overt act attributed to the petitioner. He is in custody.
Section 17 is 5 years?
13, of course, is 7 years, my lords.
7 years, right?
17
7 years.
He is charged under 13 and
हो गया.
it could be, my lords, 5 years up to life.
Yeah. So minimum is 5.
Up to life.
But life is the maximum.
Yes.
Not a mandatory life sentence as in a terrorist act.
Quite so. But here, my lords, the real charge seems to be 13. And 13, my lords, the period prescribed, my lords, is up to 5 years. 13(1) is 7 and 13(2) is 5. And in any case, my lords, 13 falls under chapter 3, which does not attract
Only that the High Court has not really touched on the merits of the bail.
That's right.
High Court has simply held that the trial court is right, holding that a prima facie case under section so and so made out. Fine. That prima facie case, this observation may be relevant for the purpose of, say, framing of charges. Or somebody who says that, who comes to the court for seeking quashing of the charge sheet or FIR, one can say, prima facie case made out, it can't be quashed. But in the matter of grant of bail, and where the variance is between 5 years to life, that part where the High Court should examine that what kind of gravity is there, and therefore in such like case, what are the other mitigating circumstances, what is the likelihood of the trial to be concluded. So all those factors which are relevant for bail, that nothing has been considered by the High Court.
I bow down. We can either place, because we have filed, the charge sheet is on record. We have filed Mala's a detailed counter. I'm carrying the statements of the protected witnesses who have deposed against him.
Only 5 witnesses
So
have
the
been
Lordship
examined.
wish to see, we can, no, 10 witnesses have now been examined, Malads. And the witnesses, total witnesses are 135, and out of which 10 have been examined. We are getting 3 dates every month, Malads. Your Lordships wish to see the merits, I can assist, Malads. It's not merely on training, Malads. Collection of funds. This is training including arms training.
So we are proposing to send the case back to the High Court. Let the High Courts also learn to that how the matter is to be decided on merits.
In your Lordship's hands, but some time-bound direction, because he has been in custody now for 3 years and 3 months. No antecedents, my lords.
So leave granted. The challenge here is to an order dated 27th August 2025, passed by a division bench of the High Court of Judicature for Rajasthan, branch of Jaipur, in a statutory communal appeal, in which the order dated 4th December 2023, passed by London Special Judge in bracket NIA cases, bracket Rajasthan, Jaipur was challenged. The special judge, by the above stated order, had declined to release the appellant on bail. The statutory appeal filed by the appellant, the concurrent order passed by the High Court admits that the High Court has dismissed the statutory appeal in terms of the reason discernible in private of the impugned order, from observing that at this stage it cannot be said that no prima facie material available on record against the appellant. So while this may be a valid reason for the purpose of proceeding with the trial, but the High Court proceeding with the trial, but not for proceeding with the trial, but this would be only one of the factors while considering the prayer for bail. So the consequential sentence being at variance from 5 years minimum to life imprisonment, it seems to us that the High Court is required to consider, that the High Court is expected to consider various factors like the gravity and nature of the offence, column 2I, the period already spent in custody, 3I, likelihood of tampering with the evidence or thing from law, 4I, the stage of the trial, 5I, likelihood of misuse of the concession of bail by indulging by repeat crime from a family circumstances and other mitigating circumstances.
We are this of the view that, that's right, we are this of the view that the matter requires an objective consideration of the relevant factors at the hands of the High Court. While deciding the subject's statutory appeal. That's correct. Consequently, without expressing any opinion on merits, the instant appeal is allowed in part to the extent that the influence order of the High Court is set aside and matters remitted to the division bench of the High Court of Jaipur to decide the criminal appeal afresh, taking into consideration all the relevant factors. Taking into consideration all the factors relevant for the grant or refusal of bail. We request the High Court to decide the bail afresh expeditiously and preferably within 6 weeks.
Grateful, Manu.
So grateful to you. Great.
Lordship, there is no election last 6 years. Your Lordship, in last 6 years there is no election, Lord. And every time they took time to hold the election. In last election had in 2020.
May I please interrupt your Lordships? It's the last para of this new status report. We are completing it shortly. This little time is because reservation took time. The last date we are asking for is 24th February. And so actually, just one second. Although actually we'll finish it before that. The last para is enough, Manoj, para 11. Para 8 gives the Lordship the reasons why this reservation of wards is a procedure which took time. Now we are at the cusp. So my work ends on 20th of February 26, which is literally one of the month away. Thereafter, the State Election Commission will take over. Their schedule, your Lordship, is not concerned as far as I am concerned. That will be decided between them and your Lordship.
But so far as the Election Commission is concerned,
I am asking for my job of notifying the reservations as on 20th February 26.
so it is draft has been notified. Final list. Final
notice, because
draft
now
has
there
been
it can't
notified.
Earlier, what was the date given?
15th of December, my lords. There's a delay of 4 days. 1 month,
More
but
than 2 months.
in effect 2 months, my lords.
Well, at last
the final
opportunity will grant.
Lordship, may
So
take the
far as the
timeline.
election.
At the last opportunity, final indulgence is shown to the state of Karnataka and its authority, including the State Election Commission. Consequently, time up to 20th February 2026 is granted for publication of final ward-wise reservation.
Please, my lords.
Lordship.
Ward-wise reservation.
Lordship.
No further explanation shall be granted in this regard. Similarly, the follow-up action shall be concluded within.
The election
So
commission
far as
is on.
Election Commission, my lords, they will tell you, Lordship.
There is the final preparation publication of the voters list is scheduled on 16th of March 2026, my lords. We have already started. The draft will be issued on 19th January.
That
The
will
schedule
be
is-
by 16th March.
The voters list will be completed, my lords. Now the exams are scheduled, my lords. So by end of May, we will start the process of elections because the 10th standard exam starts from 28th of February up to 17th March. And my lords, the second PUC exam also starts and ends by, my lords, 25th of May 2026. That's, my lords, 12th standard exams. So I will schedule it immediately upon the completion of the exams. Because I need the schools and teachers.
Before the exams.
My lords, because the schedule, my lords, by 17th March. My voter list completes on 16th March, by which time the exam.
Now this Lieutenant can say similarly, the State Election Commission undertakes to publish the final voter list by 16th March 2026. Namely, it is
fixed. Thereafter, the election process will commence on.
Lords, by May end, my lords, I'll start because the exams have to end. I don't have the staff.
Since the school's examinations are to be conducted in the
from 28th of February 2026 up to 25/5/2026.
8th February to so and so date, comma, it is directed that the elections will be held immediate thereafter and the same shall be concluded by 31st May 2026.
The elections will commence only after 26th May. The exams end on 26th May.
Only till 2 days.
Yes, Lord.
Lords, the election process itself takes one. I'll announce the election schedule, my lords, by 25th May. Your lordships
How
can
much
take.
extra days? How many extra hours or days?
No, my lords, I will not have the schools and the teachers available for me to hold. I'll announce it by, my lords, the dates of election schedule. Your lordships can take it by 15th May, my lords. Then the process will commence after 26th May, so that I have the schools available.
Election process shall be commenced soon thereafter. Soon thereafter. Soon thereafter.
26th of May.
With effect from 26th May 2026.
Yes.
Then the next schedule, then you apprise us.
That, my lords, it is almost 1 month that gets completed once I announce the schedule. The time that will get completed, my lords. That is time for filing nomination. Everything will be announced by 26th May. So your lordship can say by end of June. End of June it will be completed, including announcement of result.
The elections in all circumstances shall be concluded before 30th June 2026.
Please, my lords. Yes, my lords.
Grateful to you.
Much.
In terms of your lordship's last order, the respondent were to verify the payments.
I'm being led by the learned ASG
And-
Suprem Nataraj. I'm seeking rules. I'm being led by the learned ASG, Mr. K. M. Nataraj. I'm being led by the learned ASG, Mr. K. M. Nataraj. He's on his legs in court 7.
But this is only factual information. You might be having it.
We have filed a
Madam, some communication were sought from us on 8th of January. This, my lord, will my lords respond to it.
What are your instructions?
My instruction is 23 as per the document file NOC has been obtained out of 68 victims, my lords. Further, some payments have been made and NOCs furthers have been obtained. That will place on record. They were, in terms of your lordship's order of 17th/11, they were to verify the payments and NOC that we have placed on records.
We filed a reply saying that we've not received any such responses from him. In fact,
No, but there is a communication which came on 8th of January. To that we'll respond, my lords. We had supplied all the documents, we'll resupply again.
Have you given the details of the payments made by you?
My lords.
Have you given to them?
Well, we gave, but again they have sought for on 8th of January this year, my lords. We'll respond within a week, my lords.
in fact, our instructions are that he's started another similar scheme where he's now taking money from other investors to repay the previous investors, and this is what is being done as our instructions. And we filed the same in the status report.
Now, if he is indulging in that kind of thing, then you know what is action to be taken.
Yes.
You don't need our advice.
Yes.
So, Mr. Parthiv Goswami and Senior Counsel for the petitioners states that in compliance of para 1 of the order dated 17th November 2025, information was furnished to the respondent authorities regarding payments made by the petitioners, regarding payments made so far by the petitioners. However, further information has been sought on 9 January.
8th January.
On 9 January 2026.
8th
January. To which the petitioners undertake to submit their response within 1 week. Within 1 week. can say post the matter on so therefore further consideration.
Well, that interim orders by, well, the interim order to continue, we can apply for.
Before I address your lordships on merits, there is a suggestion if the other side is agreeable, my lords. Lord, I will not argue on merits, my lord, but I will just point out what my suggestion is. Lord, there was a dispute raised under section 9 before Bombay High Court. The court observed that better you settle. The matter was settled, which is recorded by the court. Thereafter, they sought an extension in that, and the extension also they said that by consent this order is passed. Contract is extended, etc. But the consent was not in their pleading. Despite which, they raised the same issue which was settled. Because of that issue being raised, we stopped making payment of that post-dispute amount. But if they are ready to reconcile, we are ready to pay post-dispute amount, my lord, after reconciliating the accounts.
No, Lord, my friend may put it in writing, but I have not understood what he is saying.
You can show this one page.
No, there was a settlement which was noticed by the High Court on 12th May 2023.
Right, Lord. I have completed the projects, Lord. Both the projects I have completed. I then raised an arbitration.
For the same issue, that's all.
Lord, it doesn't work like that. So, Lord,
if you are not agreeable, I will argue on merit.
I think better you argue. You can't argue.
But I believe this would be in your client's interest, but I leave it to your.
Either my friend will give it me in writing, Lord.
No, I don't give it in commitment in writing. I can.
We are willing to settle even the post settlement payments also, 23 post, that means post completion of project.
If you are willing to settle and give me the money, then what is it that you are not willing to give?
Let me, my lord,
clear what you are not willing to give. What you are willing to. Only then I will understand.
So let me show, my lord. I was not, my lord, in an adversarial mode, but let me, my lord, show some facts, my lord. Then, my lord, possibly during that course of years, my lord, my showing, he would also, my lord, immediately know, my lord, what I am exactly doing. Where is my file? Lord, please come to page 831. 831. That would be in the second volume, my lord. 831, my lord. Your lordship gets?
I don't know.
Your lordships need not, my lord, because their subsequent pages also would be relevant, my lord. Therefore, 831. Para 3, my lord, your lordship gets? My lord, Justice, I'm sorry. I'm not saying. Lord, 8, you have second copy? What do you want? My lord, Justice. I'll.
Possibility.
This is what happened.
Lord, 831. My lord, the Chief Justice has 831.
This is the.
Yes, 830 order.
It is therefore, I'm sorry. It is therefore appropriate that the parties have a joint meeting and try to resolve the disputes. In order to enable the parties to do so, stand over on so and so. Next page is, my lord, my proposal to them. And please have a look at, my lord, page 835. This is, my lord, my proposal.
Was it?
Page 835. Lord, clause C and F, no further extension of time shall be granted on account of delay for whatever reason. And F, you will execute the balance work at the same contractual rate without any price escalation towards increase in construction material, etc. Now, please see 837. My lord, this is placed before the court. At page 839, my lords. Lord, para 5. I'm sorry, para 2, my lord. My lord wants me to read para 2. Para 2, my lords. as there was a possibility of an amicable resolution of disputes, the respondent in public interest had taken a fair stand. Well, that's my client. In these circumstances, on 13th July, the court passed the following order. Well, then para 5 at page 839. It is on the similar lines and considering the public interest, learned counsel for the respondent has contended that without prejudice to proposal was issued by the respondent to petitioner on 2nd July, which I had shown to your lordship, page 832.
Where are you reading now?
I'm sorry, page 839, para 5.
Para 5.
Yes, what records that now it is settled. That's what, my lord, it is on the similar lines, your lordship gets, my lord, the Chief Justice gets. It is on the similar lines and considering the public interest, learned counsel for the respondent, that is NHI, had contended that without prejudice to proposal was issued by the respondent to the petitioner on 2nd July, which your lordships have seen, page 832, calling upon the respondent to accept the terms and conditions as set out in the said letter, a copy of which is tendered on behalf of respondent. Mr. Sen, that is Mr. Rodgi's counterpart, learned counsel for the petitioner on instructions of his clients who are present in the court, states that terms and conditions as contained in the said letter of the respondent are acceptable to the petitioners except for 3 issues being noted hereinafter. He also states that willingness of the petitioner to continue with the contract has already been recorded in para 1 of the order dated so and so. Mr. Sen says that firstly, these are the 3 problems which they had, to which we agreed. That all right, we are also agreeing. Mr. Sen says that firstly, the concern for his client is to the condition providing for a period of 45 days as set out in para 8B of the respondent's letter dated 2nd July. Mr. Sen's contention is that such period of 45 days need to be reckoned by excluding the period taken for launching of the railway girder. This contention of the petitioner is acceptable to the respondent as stated by learned counsel for the respondent on instructions from the officers who are present. The second contention urged by Mr. Sen is in regard to condition in paragraph 8D of the said letter of the respondent, which is in regard to blacklisting. Learned counsel for the respondent on instructions make a statement that the petitioner would not be blacklisted on the present contract in view of the observations as made by this court in Michigan's case Suprem. So that is taken care of.